The other couple of points on tenants' rights is that under Oregon's statute, that tenants can now, when they know they've received their trustee's notice of sale from the process server, they can ask their landlord to apply their security deposit and any prepaid rent to their rent obligation. There is a huge misconception out there that tenants, upon learning about the impending foreclosure, don't have to pay rent. They have to pay rent. And if they don't pay rent, they're going to get a 44-hour notice to vacate, or 72-hour or 144, depending on what type of tenancy. But tenants have to pay. And so recognizing that, the legislature said, okay, well, you're never going to see your security deposit anyway after the property is foreclosed. So tenants, you can go ahead and apply that towards your rent. Tenant has to notify the landlord in writing that that's what they want to do. It does create this gap situation, though, because a non-judicial foreclosure sale, the tenant has to be served notice of the sale 120 days before the date set for sale. But most security deposits and prepaid rent are only going to probably cover 2 months, maybe even less. So it really does set up a system for landlord and tenant to talk to each other. There's a lot of anger out there. I'm sure you guys have all experienced from both the sellers and tenants. You know, people are angry about what's going on. And tenants are thinking, well, they didn't use my rent money to make the payments, why should I have to pay them? So it does create a situation for dialogue, because if they don't pay, they can be evicted. If they do pay, then they're going to have rights to occupy the property following the foreclosure sale. The other component is that the federal statute that gives 90 days doesn't talk about rent. Rent is only discussed in the Oregon statute. And Oregon is really careful. Oregon's got this, huge Chapter 99, which is Residential Landlord Tenant Act. There's lots of responsibilities that landlords, if you're a landlord, subject to that act, that you have to follow. There's habitability conditions. There's just a ton of stuff that we could talk another hour about. But a buyer at a foreclosure sale does not become a landlord subject to that act unless they do one of a couple things. These are kind of no-brainers, but they sign a new rental agreement with the occupants of the home after the sale, duh. They accept rent, or, this one's interesting, they don't, the third one is sort of tricky, they don't give a 30-day notice to vacate. So I can see a big trap for the unwary here that, okay, so we've got this federal law right now that trumps Oregon's 30 days for tenants to be there. So if you represent landlords or buyers at sale, they're thinking, well, I don't need to give that 30-day notice because they get 90-day notice, so they give the 90-day notice. If they don't do that within 30 days, guess what? They're a landlord under the Residential Landlord Tenant Act. So it's a little trap to be wary of, and it's pretty complicated. And the rules are not clear and contradict each other a little bit. A result of the Oregon legislature not coordinating with Congress, shock. So just a word of caution that if you're in that situation, that you might want to talk to somebody about digging a little bit deeper into the statutes. I've got on here cash for keys. I think most people are probably aware of what cash for keys is now. And the only reason I've got it on an emerging issue is, well, very briefly, it's just that following a foreclosure sale, if the buyer has the right to occupy the premises at some point, whether it's 30 days, 90 days, 60 days, however many it happens to be, if the people don't get out of the property, then the buyer has to use the eviction process to get them out of the property. It can be lengthy, it can be time-consuming, but more importantly, there is a, my world as a lawyer, I live in what's called the parade of horribles. We're always looking at worst case scenario. So in this circumstance, this is not widespread, but it is happening, where people who are losing their homes or tenants who are going to be evicted because of the foreclosure process are trashing the houses. And they are stealing things. And we had one about a month ago, it was a heat pump, and sledgehammers to toilets. And the reason I gave the little disclaimer is, I do think it's a minority of the properties that are out there. But normally that minority in those types of extreme examples are the ones that we hear the most. So cash for keys has become a mechanism for purchasers at a foreclosure sale to get the property back by a date certain. It can be sooner than the 90 days that they'd be entitled to under federal statute. It could be 120 days, it's whatever they agree to. And it's gonna be broom swept and clean when they get that property back. And if the occupants of the property develop or turn over the property in that type of a condition, they're gonna get cash. And I have heard numbers ranging from, $1,500, $2,000, all the way up to $10,000. I heard that just last week. So it's a lot of money. But if you look at it from the buyer's perspective or the bank's perspective, it's probably cheaper in the long run to pay people to get out of the property and keep it in good condition. The added little twist is that if the person who is paying the money knows how to get a hold of the occupants, they're going to get a 1099 because it's income. And so some people are surprised when they get that and angry again, but just something to keep in mind. Let's see, there's a couple other emerging issues. Mortgage insurance and its impact on short sales and foreclosures. What's happening is there's two different types of mortgage insurance out there. Just generally speaking, you've got the mortgage insurance that's going to cover the 20% that somebody doesn't put down on a piece of property. Then you're also going to have the mortgage insurance that an investor or the lender can purchase, sometimes the borrower pays for it, that covers the full amount of the mortgage. For the purposes of what I'm talking about, it doesn't matter which type of mortgage insurance we're talking about because the same thing can happen in both cases. To set up the scenario, whether it's a short sale or a foreclosure, when the lender takes a loss, if there is mortgage insurance that would be partially covered by the insurance itself, the bank will tender the claim to the mortgage insurance company, and then the mortgage insurance company will pay the bank. The bank will go on its merry way, and then the mortgage insurance company is going to come knocking on the door of the borrower to make good on it. Now, when I first heard about this, I thought, that can't be true, because it wasn't happening very often, particularly, and it's not that it probably wasn't happening, it's just that it wasn't as widespread because there's been another sort of change in the foreclosure context, and that's that banks used to credit bid or open their bidding at a foreclosure sale at what was owed to them. It was pretty unusual for a bank to start the bidding at what was less than what was owed to them. But banks don't want properties, and so they're trying to get those properties to sell. So they are now opening the bidding at significantly, sometimes, 100 grand, less than what's owed on the loan, in the hopes that they can sell the property on the proverbial courthouse steps. If they don't, they still have to deal with that loss. So you're going to have the charge-off, you're going to have potentially a mortgage insurance claim, but it has been a fairly new, and when I say fairly new, I'm talking a year, 18 months or so, because there's now very few lenders, there still are some, that actually do their bidding at a foreclosure at the full amount of what's owed to them, but they are the exceptions now, as opposed to they used to be the rule. And then, of course, in a short sale, by definition, the lender's getting less than what's owed to it. So if it's a loan that's protected by mortgage insurance, then there's going to be that claim too. So to get back on track, when I first heard about it, I thought I need to figure out a way of putting my brain around what's happening so I can try and explain it to other people. And the best description that I could come up with is, if I were to pull it, is a car accident case. So I pull out of the parking lot today and I'm rear-ended by an uninsured motorist. I'm going to be taken care of because I carry insurance on my car, and I'm going to have, my car's going to be fixed, my neck's going to be fixed, whatever it happens to be. But my insurance company is almost always going to go after the at-fault driver for the damages that they had to pay